Okay, so I'm happy to welcome you to the Foster Family Coalition of the Northwest Territories webinar series on FASD and the justice system. We're excited to be able to provide you with this fifth and final webinar on FASD and the courts. So my name's Lisa Myers, and I'm the host of the webinar series. I'm currently the Glow and 4Y coordinator for the Foster Family Coalition, and my main role is to support youth and their navigators that are enrolled in our programs. So an important step in reconciliation is the acknowledgement of traditional treaty lands and the recognition for the people of the territory. The City of Yellowknife acknowledges that we are located in Chief Drag East Territory. From time immemorial, it has been the traditional land of the Yellowknife Dene First Nation, and more recently, the homeland of the North Slave Métis Alliance. We respect the histories, languages, and cultures of First Nations, Métis, Inuit, and all First Peoples of Canada, whose presence continues to enrich our vibrant community. So a few housekeeping items before we get going. We will be recording all of these presentations, and they will be available on the Foster Family Coalition's website at the end of October. This Zoom also has the Q&A function where participants can ask questions and upvote these questions so that the most common will rise to the top. There'll be time after the presentations to ask these questions to the speakers. Please indicate in the Q&A if your question is directed to a specific speaker. So I would now like to introduce our speakers for today. So we have Dr. Caitlin McLaughlin and Professor Glenn Luther. So Dr. Caitlin McLaughlin is an assistant professor in the CPA accredited clinical psychology program in the University of Guelph. And the Canada FASD Research Network lead in justice. So Dr. McLaughlin is a clinical psychologist who completed graduate training with a forensic specialization at Simon Fraser University and subsequent postdoctoral training as a fellow with the Kids Brain Health Network with concurrent appointments in the Department of Pediatrics in the University of Alberta and the Child and Family Research Institute, Development Neurosciences and Child Health at the University of British Columbia. Dr. McLaughlin also holds an adjunct faculty affiliation, the Department of Psychiatry and Behavioural Neurosciences at McMaster University, and is a member of the Peter Boris Centre for Addictions Research at St. Joseph's Healthcare, Hamilton. So we have Professor Luther joins from the faculty of the College of Law, University of Saskatchewan in 2003, having previously held teaching positions at Osgoode Hall Law School, Victoria University in Wellington, New Zealand, and the University of Calgary. He's argued cases throughout Alberta and Saskatchewan at all levels of court, including the Supreme Court of Canada. Professor Luther has published extensively in the criminal procedure area. His academic interests include police powers, the Charter of Rights and Freedoms, criminal law, procedure and sentencing, evidence law, and mental health law. He's also the co-author of Detention and Arrest with Professor Stephen Coughlin of Dalhousie University, and it's now in its second 2017 edition published by Irwin Law. So I would like to hand it over to both of our speakers for today.
Thanks so much for that introduction, Lisa, and thank you to everyone, CanFASD, and for being invited to speak today. It's a pleasure to join you. I'm going to kick things off. I'm going to speak for around 15 or 20 minutes, and then Glenn's going to add his piece. We're going to cross our fingers and toes for no technical difficulties, but be gentle with ourselves and others if we run into any. And I'm just going to get my slides going. Glenn, can you see that? You're the only person. Oh, thumbs up. Awesome. Perfect. So welcome, everyone. And I'm joining you today from, well, I work at the University of Guelph, and I've included a map here so that you can see whereabouts we're located, just outside the city of Toronto in Ontario. And today I'm actually joining you from my living room amidst the pandemic, situated on the traditional territories of the Haudenosaunee and Anishinaabe nations, and from within the lands protected within the Dish with One Spoon Wampum Agreement. It's my real pleasure to be here, and feel free to jot down questions and put them in the chat and chime in at the end of this session. We'd be happy to answer them. The other thing I'll mention briefly is that I'm going to speak to you today from the perspective of both a clinical psychologist and also a forensic psychologist. And for those less familiar about that area of specialization, it involves intersections between issues like mental health and neurodevelopmental disability as they come together with the legal system. And my research and background tends to focus on the criminal justice system, including vulnerable folks who become involved in the criminal justice system, in particular youth and folks with fetal alcohol spectrum disorder. So in case we have any new folks joining us today, I'm just going to give a brief reminder that FASD is a common neurodevelopmental disability, thought to estimate around conservatively 4% of the population in Canada. That's just over 1.5 million people. But I will say that research is limited in this way, and for lots of reasons I'm going to chat about briefly today, you'll see that experts believe this is thought to be an under reflection of the true number of people who could have FASD across Canada. FASD has lifelong impacts on the brain and body of individuals who have been prenatally exposed to alcohol. And importantly, I think it's really important to always mention the context that FASD and prenatal alcohol exposure occur in the context of social determinants of health and in all populations where alcohol is used. That individuals with FASD, like everyone, are unique, and like everyone, have both areas of strengths and challenges, and that with supports, these strengths can be leveraged and all can achieve positive and healthy outcomes. At the same time, some of the reason that we're together today here to speak about difficulties related to the criminal justice system are the result of continued difficulties with being able to effectively identify and recognize people who may be experiencing difficulties related to the effects of fetal alcohol spectrum disorder. And without that appropriate recognition, this makes it very difficult to put into place the right kinds of supports and tailored services. And ultimately, this can contribute to a range of additional complex needs. One of the other things I meant to mention right at the beginning of the session today is that I'm going to very briefly mention a number of adversities that are experienced at elevated rates by people with FASD, including a brief mention of trauma and suicide. And so as we're all coming together amidst the pandemic and challenging times, feel free to come and go from our webinar today. And as I understand, it will be recorded. Feel free to join and view it another time, depending on how you're doing in this place and time and space. So today and across this entire series, we're talking about the intersection between FASD and the criminal justice system and legal contexts more broadly. I think it's important, as I've alluded to, and to mention directly that not everyone with FASD ends up experiencing difficulties related to coming into contact with the criminal justice system, that some folks do, and that folks with FASD more broadly as a group may be at elevated risk of having these experiences. But that also importantly, folks who do come into contact with the criminal justice system can benefit from effective supports and services and be supported to effectively disengage from contact with the criminal justice system. To give you a little bit of data around how many folks we think with FASD may have experiences or come into contact with the criminal justice system. I'll talk to you about some prevalence data that we have from studies conducted here in Canada and internationally, but I'll add the caveat that lots of these studies have been conducted in single institutions or smaller geographic locations, and that they may not generalize in the same ways to everywhere else in a country or a jurisdiction. And you'll hear me say a number of times today that we certainly need more research to best understand trajectories and pathways to support healthy outcomes for folks with FASD with a justice focus. So we take that 4% estimate that we think is a conservative but reasonable number to work with in Canada. We can see on the left in the general population that that is a much lower rate than the prevalence estimates we've seen in provincial and territorial and international studies involving youth, men, women, and different levels of incarceration, which range anywhere from 10% to 36% of people seen in research. So those numbers are much greater as compared to the general population. In addition, a small number of studies, including one that I'll show you a bit more detail about right now, and Dr. Anne Streisku's original seminal research have shown that amongst people who are being seen for a diagnosis of FASD in a clinic, rates are much elevated in terms of having had some kind of prior contact with the criminal justice system compared to the general population. So amongst these studies, as many as between 30 and 60% of people presenting to clinic have had that kind of difficulty. Taken together, these estimates suggest that youth may be 19 times more likely to be incarcerated, youth with FASD compared to youth without FASD, and that correctional prevalence estimates are 30 times greater compared to the general population. So while not everybody with FASD is going to experience this kind of difficulty, we can say that when we turn in toward focused criminal justice and legal settings, folks with FASD do increasingly appear to be overrepresented, with increasing evidence suggesting that this is the case. So I mentioned earlier, I was going to share a little bit of Canadian data. These data come from the Canadian National FASD Data Forum. This is a joint research collaboration led by Dr. Jocelyn Cook and provided with support by the Canada FASD Research Network and the Public Health Agency of Canada, that allows clinics from all over the country to provide completely anonymized information about individuals being seen for an FASD diagnosis into a secure cloud-based data repository that lets us get a snapshot and a picture into the kinds of experiences and needs that folks with FASD in Canada who are coming to clinic have. And this is a really truly powerful resource from a research perspective. Last year, we wanted to better understand some of the kinds of everyday difficulties that people with FASD in Canada were experiencing. And so today I'm going to show you, you can see I've highlighted there on the screen that of the 726 adolescents, transitioned aged youth and adults included in our study, between 33 and 24%, 33% of adolescents, 36% of transition to age youth, and 24% of adults were experiencing some kind of current difficulty related to legal problems with offending, and that rates of incarceration were lower amongst youth. This is not surprising given patterns across Canada, but they ranged as high as 10% of individuals across the entire sample. So these data give us an indication that this is a difficulty that folks with FASD here in Canada are experiencing, in addition to, as you can see from across the rest of the slide, very high rates of different kinds of difficulties across areas of daily living, including problems related to employment, living independently, housing difficulties, and difficulties relating to alcohol and substance use. So one of the areas that we have less rigorous research to really support understanding is in trying to determine what are the risk factors that are impacting the kinds of trajectories that get set up and may place somebody, a young person or an adult with FASD, at elevated risk for coming into contact with the criminal justice system. We don't to date have any terrific longitudinal studies that follow folks from childhood through different developmental periods to really understand the kinds of experiences and risks that may shape those trajectories. But we do have some ideas based on our understanding of the kinds of needs folks with FASD present with. From a neurodevelopmental perspective, they experience a wide range of varying and significant impacts to their overall cognition and more specific areas, including executive functioning, academic achievement, memory, attention, and executive functioning, as well as adaptive behavior or difficulties with independent activities of daily living, akin to those I just shared. In the criminal justice context, sometimes I'll get a common question that says, well, many people who are involved in the criminal justice system experience complex cognitive impairment and other kinds of mental health related needs. Is FASD any different from folks with other kinds of neurodevelopmental disorders or mental health concerns? And these data that I'm showing you now are from our Northern Correctional Territorial study of FASD prevalence. You can see here in the middle, this is a sample of 80 people who underwent comprehensive assessments with a multidisciplinary team for FASD. Here, counter to what you might expect, 0 is a score in a Z score that is consistent with average sort of functioning across the entire population, across a range of cognitive areas of functioning like academics, attention, and memory, for instance. You can see down below that folks who ended up being diagnosed with FASD, as well as folks in that red choppy line where the clinical team wasn't quite sure whether they had FASD or not, experienced much, much worse functioning compared to those here in a group of individuals who had a range of difficulties related to their cognitive functioning that the clinical team did not think were ascribed to FASD, as well as much lower functioning as compared to the folks who were considered to have neurotypical functioning, and everyone in this group is justice involved. So you can see that across many areas of functioning, folks with FASD are appearing to have more complex deficits and more greater levels of need compared to other folks who went through the same comprehensive diagnostic process. Glenn's going to speak a little bit more about this in respect to legal implications when we turn it over to his side of the presentation. But these kinds of difficulties in neurodevelopmental functioning can lead to a number of practical challenges that can cause serious difficulties for a person navigating all aspects of the criminal justice system. These include difficulties in reasoning, communicating effectively, controlling impulses, making sound decisions in stressful contexts, being more psychosocially immature than peers, having increased levels of suggestibility, and importantly, as I've mentioned and we talk a lot about, in ways that may be masked or not immediately readily apparent to even trained professionals sometimes. So this can make somebody look or seem a lot more socially able and sort of have much, let me try that again. They can look like they have much less difficulty in their functioning because of that ability to sort of compensate. In addition, we know that different kinds of early life adversity greatly increase risk for somebody experiencing a range of poor outcomes, including involvement in the criminal justice system. We also know with increasing research that rates of adversity and early life difficulties are elevated in many folks who have FASD. These include difficulties related to caregiving disruptions, abuse and neglect and trauma, early school disruption, and later difficulties related to employment and precarious housing. So these together then with very high rates of additional comorbidity. So studies showing that as many as 90%, as high as 90%, estimates suggest that people with FASD may present with another co-occurring mental health or neurodevelopmental disorder, and very high rates of additional kinds of physical health problems. One study estimated as many as 400 additional physical and mental health related comorbidities, creates this complex picture that when not appropriately detected and supported can come together to increase that risk. These are data from a study that we conducted some years ago now in 50 justice-involved youth with 50 justice-involved youth with FASD and 50 justice-involved youth without FASD. And I just wanted to show you that the youth with FASD, while all of the justice-involved youth had very high rates of early life adversity and trauma, those with FASD often experienced much greater rates of those kinds of difficulties. They also presented with much greater rates of elevated clinical needs and experiences of having been previously hospitalized for psychiatric reasons, much greater and elevated rates of suicide attempts, and more elevated rates of overdose. And these are the kinds of things that we see in a population with increased mental health difficulties, substance use, and difficulties related to impulse control. So these needs are complex and elevated in the limited data that we do have. Importantly, the field is increasingly recognizing the importance of adopting a strengths-based perspective and not just operating from a deficit-based perspective in supporting the needs of youth with FASD. And indeed, emerging research suggests that there are a number of important protective factors that can help leverage strengths and reduce adverse consequences and outcomes associated with criminal justice and reoffense risk. Some studies have shown that factors like hope, willingness to change, and resilience are linked with more positive outcomes for people who have been justice involved. Our earliest and best evidence suggests that early detection and diagnosis, coupled with the provision of appropriate supports, help mediate against adverse outcomes. In addition, lowering rates of substance use have been shown to be associated with reduced criminal justice system contact, and that protective factors more broadly have a reverse relationship, such that the more protective factors you have present, the less likely or the lower your risk of engaging in recidivism or aggression for people who have already been involved in the criminal justice system. So this is a really important component of our support planning that we need to keep in mind for this population. I've mentioned a couple of times that people with FASD remain highly underdetected and misdiagnosed. Sometimes we call folks with FASD an invisible population because so few present with overt physical discerning characteristics, and this can make it really tricky to identify people with FASD and get those early supports in place to impact healthy trajectories at early stages. So what could be going on? What factors contribute to this? As I mentioned, as few as 10% of people with FASD, particularly as they age, may have outwardly physical discernible features that would allow somebody to identify that someone could have FASD without doing further clinical investigation. I've mentioned that there's a lot of ranging and wide-ranging variability in terms of the deficits, strengths, and needs that folks with FASD may have, which can create a complex clinical picture and result in not quite the diagnosis being rendered that's needed when clinicians are seeing folks with FASD. It remains a challenge. It can be very difficult to get reliable information about prenatal alcohol exposure to make a confirmed diagnosis, which is required in many cases. And this is coupled and paired with the huge stigma experienced by people with FASD in the context of also prenatal alcohol exposure, reminding us that we need to really have FASD-informed practices and be sensitive and supportive when inquiring about this area. We know that across Canada, we face really still exceptionally limited diagnostic resources. And this is incredibly true for justice contexts where there may not be funded pathways available, particularly for adults to be seen for a fulsome assessment and diagnosis. And our own research and the research of others tells us that professionals and clinicians across a range of disciplines, including forensic mental health professionals, continue to have insufficient professional knowledge and training to really be able to most effectively support this population. So I'll just briefly mention a couple of areas that we think focus could help us work towards improving outcomes, including those with a legal focus. And I know Glenn's going to elaborate on several of these. Research tells us that providing appropriate training and skills for criminal justice, legal, and clinicians involved in forensic capacities can greatly improve not only our early recognition, but capacity to effectively support and prevent youth and adults with FASD from becoming justice involved. We're doing a lot of work right now around trying to be able to support effective and evidence-based early identification and screening programs that can help identify folks who may be at risk of having FASD. Professionals and care providers respond more effectively to that person, as well as identify who may need to go forward for more comprehensive evaluations and diagnostic assessments. Having comprehensive assessment and diagnosis, ideally through an FASD lens by a multidisciplinary team, is really the gold standard for being able to identify the kinds of needs that someone with FASD has. And at the same time, that resource is often not available, or there may be very long wait lists to try and provide those kinds of evaluations. So ensuring that the kinds of areas like neuropsychological functioning and medical health, speech and language pathology, or occupational therapy, ensuring that assessments of the needs and abilities and strengths in those areas are completed is another really important tool in our toolkit that we can use to best understand these needs while we're waiting for more comprehensive evaluations. And this can be very important for folks who become justice involved to also add a specialized forensic assessment. Forensic mental health clinicians are trained not only in the common areas of clinical practice that would be relevant to complete an evidence-based assessment, but they're also trained to understand the legal and forensic impacts that are important not only for informing the court in respect to the kinds of decisions that need to be made, but also in ensuring that behaviors that can increase somebody's risk of becoming involved in the criminal justice system or more overt offending and illegal behaviors can be managed appropriately. They tend to have specialized training around issues related to aggression, violence, difficult sexual behavior, and other kinds of areas that may require a specialized lens. When those experts may not be available, ensuring that we reach out and engage in appropriate consultation and referral is another really important pathway. And as I think Glenn's going to talk a little bit about in his section coming up next, adjusting practice and providing accommodations to really meet somebody where they're at in terms of both their strengths and their needs is critical across the legal system and more broadly in our everyday support for folks with FASD. So I'll just leave you with a couple of quick take-home messages. I would argue that FASD, even in the criminal justice context, should be considered a major public health issue, given rates of unmet needs and prevalence that we've talked about already today. That there are really important research gaps and directions that must be filled in order to understand and support healthy outcomes and trajectories toward and beyond the criminal justice context with a prevention lens in mind. That we really need to have this evidence to effectively support policy decisions in order to ensure that the kinds of policy choices that are made actually result in improved outcomes for people with FASD in justice contexts, and that policy responses be evidence-based, as I mentioned, and intersectoral. So working together with systems within and beyond the criminal justice context are really critical for making effective change. So I'd like to acknowledge lots of collaborators, too many to mention today, the participants and clinics who have been involved in our research and given so generously of their time and funding from a number of really important agencies without whom this research wouldn't be possible. And I will turn it over to you, Glenn. I'm sort of on time.
Thanks. No, that was great. So let me get my slides up. Okay, so I also want to say thanks for the introduction, Lisa. I also wanted to mention that I had the pleasure of spending approximately 4 months total in Nunavut with the Nunavut law program, which I believe most of you will know has been running for the last 4 years. 23 students, I believe, are graduating with University of Saskatchewan law degrees, and their graduation ceremony is actually this weekend. There's at least one of them in Yellowknife articling, as I understand it, and the others are going to be articling. So it was a great pleasure for me to spend some time in Northern Canada and to learn a little bit about Nunavut in particular. I haven't personally been to Northwest Territories or the Yukon, and certainly a place that I wish to go. So I was able to teach them or lead 3 different classes up there, and we also ran a one-day conference in April in Nunavut on FASD and the justice process. So Caitlin has sort of introduced you to a lot of the work that she does, and I'll come back to that in a minute, the importance of some of that work, in particular to the legal system, because I think lawyers need help in dealing with FASD. You know, as the slide says, it's clear that at almost every stage of the criminal process, FASD has an impact. And some of the work we've done with CanFASD, which I'll mention at the end, will give you more details. In the sort of 15 minutes I have, obviously I can't do very much about each of those, but I'll try to highlight some of the examples of what I believe lawyers need to think about and the legal system needs to think about. There's been all kinds of work about FASD and calls for action. The one on the top left I'll mention, if you haven't seen, is through an organization called the Institute of Health Economics. It was a 4 or 5 day conference in Edmonton some 7 or 8 years ago now, led by former Supreme Court of Canada Justice Binney. It is a very good document and is a very good place for lawyers to start to look for answers and assistance. Both the Canadian Bar and the ABA have made recommendations related to FASD that have seemed to be largely ignored, and most particularly the Canadian Bar Association has recommended a change to the criminal code to allow a judge to order an FASD assessment. That hasn't happened, and I'll come back to that in a minute. The Office of the Correctional Investigator and, of course, the Truth and Reconciliation Commission have had lots to say about FASD, and you'll see 33 and 34 are particular of the, sorry, I'm forgetting the name of what they called them, but of the items that they recommended. You'll see that there has been some work doing on those. I mean, I was involved in research around 34.4. It was kind of a frustrating experience with federal justice, I will say, because we did the whole project and they rejected our answers and didn't want it much more narrow. And so it's been a bit frustrating, but I know the federal Justice Department is working on these things, and one hopes that we'll see more and more coming out now that the election's over in regard to that. There's just basically some quotes here in the next 2 slides as to problems and issues. There really is no question that the criminal process is hurting people with FASD and is actually damaging our society rather than assisting, at least in my view. It's highly important that we all understand this sort of circle or the revolving door nature of the offending done by people with FASD and other vulnerable people as well. But as you learn more and more about FASD and you start to look at a slide like this, you start to see, yes, in fact, it is a revolving door. Things like, for example, and I'm just going to move this so I can see better. The police's interaction with people with FASD, the fact that they're down in the bottom left leads to arrests and rearrests. Something as simple as a person with FASD is often someone who has an impulsive reaction and sometimes is very sensitive to being touched. So that reaction with the police officer of someone who, sort of strikes out at the officer as soon as the officer touches their arm, most often that's going to result in them being taken to the ground. And notice that in an FASD person suffering with FASD, there's no malintent or malfeasance there. This is something, the more the police understand that this might be a person with FASD, that they're going to be very sensitive to touch, the less likely the police are going to misinterpret the action of that accused. But you could go around this slide forever and think about all of the things that happen with respect to people with FASD and how, because of that invisible nature of the condition that Kate talked about, notice they're often not identified. I want to say to you, though, that as a lawyer of now 40 years and a criminal lawyer practicing for a long time in Alberta, in particular for about 25 years, I feel now that I can recognize FASD. The more I'm involved with the person, I'm not always going to be right, but the red flags, which is what a phrase that the group of us that have worked with CanFASD on training seminars have come up with, the red flags are obvious to me now. The more I know about it, the more I think back of all these cases I dealt with all over the years and the frustration that I felt with my clients often. Why aren't they learning? Why aren't they changing their behavior? Why is this keep going on? So much so that clients would occasionally actually go get a different lawyer because they were embarrassed to talk to me because I had lectured them about not doing it again. Don't get involved. You got to get away from that group of people. And when I did see them in court, that's what they'd say to me. I'd say, why have you got a new lawyer? Oh, Glenn, I'm just embarrassed to see you. I can't believe I'm back here. They themselves don't understand that they're back there. But as a lawyer, I basically failed those clients. Now that I know what I know about FASD, I believe I could have been arguing other things. I could have been making different submissions, getting them assessed, and so on. So here's Judge Truman. I just love this quote. I won't read it to you, but it's obvious, I think, that we should learn by now that it's us that needs to change. Those of us that are not cognitively disabled. How do we change our reaction? Not just criminal defense lawyers, but crowns and judges, probation officers, police officers, everyone involved in the process. So, executive functioning is one of the 9 or 10 brain domains. There's no, Kate had those up in her slides. It is one that, not everyone with FASD has a problem with executive functioning, but everybody with that's been diagnosed with FASD is going to have a significant impairment in 3 or more brain domains. And often that relates to executive functioning for those that are involved in the criminal justice system. And notice these are the kinds of things that they have. And these are the red flags that often you should be looking for. They often can mask their lack of understanding. But if you explore that further, you will find that out. They're often social tact is sort of an interesting one to me. They're often very, very enthusiastic and pleasant. I recently had a grad student who was doing some work on dangerous offenders, which is another area that we're working on in some research in Saskatchewan about dangerous offenders with FASD, which I think is a particular problem in our system. And this grad student goes, well, I'm really sort of afraid to go see them. And I go see them in the jail and talk to them. And I'm going, why would you be afraid? Well, they're dangerous offenders. And I said, I guarantee you'll come back not feeling that. And she did. And she came back and said, I can't believe I was afraid. There's nothing to be afraid of in all of them. Again, those kinds of keys become very important. But also notice these are the things that get them into problems. Notice the words comorbidity, which Kate sort of quickly went over, but notice no one is going to have FASD alone. Somebody with FASD is almost certainly going to have another mental health problem. It might be the more traditional functional disorders like schizophrenia or something else, but it will often, of course, be substance use disorder. It may be ADHD, maybe other things. I'm not a doctor, so I'm not going to go any further, but you should expect that someone's going to have multiple mental health problems, not a single problem. And that makes them also unique. Our point to you generally is that I think the legal system largely misses people with FASD and treats them as those that are dangerous with a lot, even if they recognize they have a mental impairment, they'll then see it as a lifelong, non-curable condition, and therefore this person is particularly dangerous. I'll highlight briefly false confessions. The case of Henry is hard to find. You can find it only on Quick Law. It's the only place I've been able to find it. If you have access to that, it's simply an example of a judge who excluded a statement because someone had FASD and he felt that they did not understand their interaction with the police. There is an operating mind requirement that's often forgotten about in the voluntariness analysis, which seems to be what the judge did there. I'll also highlight the Tena Pora case from New Zealand. This is a case that's very interesting. It went all the way to the House of Lords, or as you would know, the Judicial Committee of the Privy Council, which I think no longer exists, but at the time, in 2015, it's the highest court in the world that's recognized FASD. There's a large discussion of FASD in the Judicial Committee's judgment, but this is a wrongful conviction for murder of someone who confessed to murder. I mean, he did not do it. He wasn't there. He fully admitted it. It went to trial twice. He was convicted both times on the basis of his confession. So notice, people with FASD will sometimes confess to things they didn't do. And we need to understand and accept that that's true. And particularly defense lawyers need to see that that might well be the case with your client. Bail, FASD people with FASD are almost designed to be held, if you put it that way. If you think of the traditional way we deal with bail, these are people that will breach. These are people that can't follow conditions often. Will fail to understand the conditions that we put on. We'll put too many conditions on. Judges love to say that I need to keep tabs on these people. And I guess I say as a lawyer, no, you don't, judge. It's not your job. It's not your job to keep tabs on anybody, particularly when they're out on bail. And I think happily 493.1 and 493.2 of the code have now come into force. As of 2019, that's a Bill C7, part of Bill C75, and it insists that we need conditions that they can reasonably comply with. The presence or absence of FASD with the particular accused, if that is raised, that should make a difference in terms of the kinds of conditions that are put on someone. And again, 493.2 talks about other vulnerable and disadvantaged individuals. So it doesn't have to be an Indigenous individual. The other thing I want to say is the principles around therapeutic jurisprudence and restorative justice are highly important when one thinks about how we might change the criminal justice system. I'm assuming, certainly in the Yukon, I'm aware of the wellness court, and I'm assuming there's similar programs going on in in Yellowknife. I know some movement in Nunavut to do more with therapeutic jurisprudence. That is, ask ourselves as lawyers, are we helping the people that we are serving? Are we actually being helpful to them? Are we helping them have a better life? What is the job that we're doing or should be doing? And of course, restorative justice could be a talk all on itself. This slide just sort of gives you some examples of things that might be raised, whether it's mental disorder or unfit to stand trial. That both, what we know legally is that FASD is a mental disorder in the definition of the criminal code, or a disease of the mind. There's really no question about that. The unfit to stand trial cases make that most clear. We argued, that is my friend Dr. Mansfield Mela, is forensic psychiatrist and a close collaborator of myself, argued for a new verdict called diminished capacity. That is, that the criminal code should actually be amended to recognize cognitive impairments. I actually argue that we shouldn't put FASD in the criminal code. So some of the MPs will be upset with me for saying that because they've been trying to mend the criminal code. 3 bills have gone forward. I would argue that we shouldn't be mentioning FASD particularly. We should be talking about neurocognitive impairments and don't put a premium on diagnosis of FASD. I think diagnosis of FASD is highly important. It can be very helpful to the accused and so on, but to make it a precondition for FASD to be a mitigating factor, to use sentencing language, is a mistake in my view, simply because we don't always have the ability to diagnose. Not just because of it's difficult to diagnose, it's difficult to have a fair and accurate conversation with the mother because of shame and other things that Caitlin talked about. And it's also, we don't have the resources. I mean, we just don't have the experts that can do this to everyone. And so as a criminal lawyer, I think that all the criminal law needs to know is this person cognitively impaired, and how are they cognitively impaired? Whether it's FASD or an acquired brain injury or something else, I don't think should be a premium for our purposes. I think it's important for other purposes, but I'm not sure it is for criminal law. There is at least one case where an accused has been found not criminally responsible, and I've given you the site there. The words degree of responsibility and 718.1 have become the touchstone for sentencing, and I'll talk a little bit more about that. That is the so-called fundamental principle of sentencing in 718.1, which encourages a court to compare the gravity of the balance, the gravity of the offense against the degree of responsibility of the offender. So those words have become the key ones for most courts of appeal in the country to talk about. And there's an interesting article about fetal alcohol spectrum disorder out of Western Australia that I've cited for you there, that you could do some more reading on that if you wish. Through a series of recent Court of Appeal judgments that I've cited in this slide, that is Friesen and Charlie, that some of you may be familiar with in the North, and most recently the Saskatchewan Court of Appeal decision in JP, we finally got to the point where courts want to recognize that not just GLADU should result in a reduction in sentence, but so should FASD, that they result in a reduction of responsibility, and thus, sort of ipso facto, a lesser sentence follows. There's really no question about that. Whether it's an incarceration, whether it's a provincial jail sentence or territorial jail sentence, or whether it's a fine, each one of those sentences should be reduced as a result of the presence of FASD or GLADU factors, and certainly with both. The other key point to get from which started in Charlie, went through Friesen and now JP, is that the word rehabilitation has been misunderstood by most judges dealing with FASD. Again, I mentioned earlier how there's sort of this feeling, and their judges have been told over the last 20 years, and I think this is really a mistake by some of us in the industry, that is, of working with FASD, a mistake in messaging. This idea that is a lifelong non-curable condition was being misheard by judges to say that this person will always be like this, and they will always commit crimes, and they will always be a revolving door coming back and back. And of course, that's not true. In particular, the work that Caitlin and others through CanFASD have been doing have shown that, and I'll come back to that in just a sec. So what does rehabilitation mean? Well, it means treatment. It's a bit like saying someone recently disclosed to me that they've got something that they call blood cancer. And they tell me that the judge or the doctors told them that they could die in 6 months, within 6 months, that's their prognosis. But that they were told several stories of people that live for 12 to 18 years with appropriate treatment. So it's not curing blood cancer, but they are treating blood cancer and extending the person's life. And we're suggesting that the same thing is true. And that's what JP says, that management and supervision in the community can well be treatment, can be rehabilitation. We need to help people with FASD to make appropriate decisions, that they're bad at making decisions, they're impulsive in making decisions, and so on. And therefore, if we can do something about that, that's what we need to do. And you'll see a case comment there if you're interested, where we've written more about this with my friend Hillary Peterson, an Indigenous lawyer in Saskatoon. Quickly, jurisdiction courts to order FASD assessments. I think it could have very much depend on which jurisdiction in Canada you're in. I have not done the research for the North, and I'll leave that to someone that is practicing up there. But you know, in Saskatchewan, we've gone around and around and around on this. Where we seem to have got to since 2019 with the 3 cases I mentioned is that the courts have recognized that even though the criminal code doesn't say anything about Gladue reports, that courts do have jurisdiction to order Gladue reports in appropriate cases. And so that jurisdiction seems to come from 718.2e. They're not particularly clear. I mean, it started by the Queen's Bench saying, well, we have an inherent jurisdiction to do this. That leaves the provincial court without jurisdiction, I guess. On the other hand, we now have the provincial courts recognizing that their power comes through 718.2e. So we seem to be getting Gladue reports. At least there's jurisdiction to order it. Judges in Saskatchewan, unfortunately, still aren't ordering them very often, which is very frustrating to me. But I would suggest that the same analysis is about FASD assessments. I mean, partly to see that we don't have a provision of the criminal code that allows a court to order an FASD assessment or even a psychiatric assessment for the purposes of sentencing. It simply says you can do it for NCR or for fitness to stand trial. So if you want to raise it for sentencing, if that's what you're applying to the judge, there's no provision that allows the court to do that. So do they have the inherent jurisdiction? Is it somehow that the courts can order it? Weirdly, in Saskatchewan, some of the judges tell me that court services has actually told them that they will pay for FASD assessments, but don't apply for too many, or don't order too many because we don't have the money. So you got this sort of, you know, backroom sort of deal stuff happening, which is good and bad. I mean, you know, if the judges know what they're doing, then you know, it's allowed us to get reports in you know, maybe 100 cases over the years, but the numbers are way larger than that. So there's still a problem in terms of jurisdiction to order these kinds of assessments. As I said earlier, both the CBA and the TRC have recommended amendments to the criminal code in this regard. It hasn't happened. And you know, maybe in your jurisdiction, you can convince your government to change your Mental Health Act to have a provision that allows them, the province or the territory, to pay for and authorize FASD assessments, which is what's happened in Ontario. I mean, so the case of Leonard, and this has been around for a long time in Ontario, there's just a section that comes out of nowhere in the Mental Health Act of Ontario that says the court can order a psychiatric assessment if it's appropriate. And it doesn't even talk about criminal cases, and the Court of Appeal said that's okay. The fact that Ontario has that, by the way, is in a sort of odd way preventing this to get to the Supreme Court. You know, if that provision wasn't in the Ontario Mental Health Act, I think a case would have made it to the Supreme Court already out of that jurisdiction. But that's simply saying that we, that is Saskatchewan lawyers, Northwest Territory lawyers, aren't doing the necessary work to get an answer to this. That we need to make sure that we can get assessments ordered in appropriate cases. Check my time. Okay, I better finish. I simply wanted to highlight that, you know, as you think about how we change behavior, it's something to do with mentorship. It's about surrounding the individual with support and mentorship. And, you know, so you have a mentor, the mentor has connections to all the people on the slide and can help that accused or that person lead a better life and make better decisions. I mean, that's the sort of strength-based approach as I understand it. But again, I'm not the expert in that. One key point that I want you to see is that as my friend Carolyn Tate did this research, and her submission is that we have to recognize that if we're going to give support, it has to be permanent. The fact that the condition is permanent means that the person's not going to learn necessarily from what the support they give. They need that support on an ongoing, continuing basis. And therefore, governments need to support that and need to not use the sort of traditional approach of going, well, we'll give good support at the beginning, and then as they learn, we'll sort of wean them off it, because that's not going to work. This is simply telling you how to maybe deal with clients with trauma, clients with FASD often come hand in hand. They're going to miss appointments. They're going to, you know, miss court meetings if people don't help them get to meetings, and all of those kinds of things. You need to recognize that. I heard one speaker say, if they want to meet me in their car, in my parking lot, that's where it'll happen. Why does it have to be in a law firm, the big fancy doors or whatever? They sit in your parking lot, get afraid to come in to see you, and therefore they don't. And I encourage you, when a client doesn't show up, go look in the parking lot. They may well be there. This final slides here just give you some additional. If you haven't heard Myrna McCallum's work on the trauma-informed lawyer, you're missing out. This is a fantastic podcast that all of us can learn from. And there's a trauma-informed toolkit for lawyers also at that website that I mentioned here. David Bolding is another lawyer who's done a lot of work on this, and I encourage you to look at that website. He's got a lot of these stick men drawing video things that are really good at explaining what FASD is about. And as I mentioned, CanFASD has been bringing together, I think they consider us an expert panel of some 20 of us, and we've got together 2 or 3 times now as a group for 2 or 3 days, and have worked on these level 2 legal professional videos. There's sort of videos, training processes that have lots of questions in them. We're very proud of them. A lot of work went into them, and I certainly encourage you to work through that. And there's just one example of Jackie Pye's work, who's part of our group as well, talking about strengths among individuals with FASD. So I'll finish there and ask whether there's any questions.
We have a few questions that have come through on the chat. They haven't been placed in the Q&A, but I can go through them. So the first question we got was, when individuals do not have a diagnosis of FASD but present with low cognitive abilities and other characteristics, is there a way that we can provide this information to the court to support the client?
I would say yes. I would argue that depending on exactly what evidence you have, notice that experts, and this happened in, for example, a famous case that I can't remember the name of the case, but it's the lost shooting case, for example. A young boy kills 4 people over lunch hour. My friend Dr. Mela went and saw him, interviewed the mother. The mother says, I wasn't drinking when I was pregnant. And so Mela comes forward and says he probably has FASD, but I couldn't confirm maternal drinking. Along comes the Gladue report writer, who's an Indigenous woman. She talks to the mother, and the mother admits drinking and to her. And so that evidence is put before the judge. And the judge, with the greatest respect, I think, misinterpreted it. She felt the mother was a liar, didn't believe what the mother said to the Gladue report writer. And I think that the judge really was not FASD informed. I mean, if the judge was FASD informed and thought about that situation, to me, it's relatively obvious that the mother didn't feel comfortable with Dr. Mela, who is an African male, right? And of high status. And so, it seemed to me the mother was probably not prepared to disclose to him. But where does it say that you have to prove this beyond a reasonable doubt or something in sentencing? It doesn't say that. I mean, if it's a mitigating factor, the code says you have to prove it on the balance of probabilities. But the fact finder needs to be FASD informed. So I encourage all judges to start to learn about FASD. I argued a case not recently, but maybe 5 years ago, before a judge in Alberta who wanted to say to me, my client had something called ARND, which is language you don't use anymore. And that's what the report, Dr. Mela talked about, ARND. And the judge says to me, well, how do I know that she's got FASD when it says ARND? And so here I am as a lawyer suddenly having to explain to this judge, in a rural place, what ARND is, and am I giving evidence? How does that work? And interesting, I think that judge, by the way, took a break. He says, I need a break. During the submission, I mentioned Judge Karen Ruddy, who is one of the really well-informed judges that I'm aware of, who's from the North. I believe I mentioned her, and I said, I spoke to her, and this was sort of a tactic of mine, and I knew this judge pretty well. I'm pretty sure he went out and phoned her and confirmed what I said was right, and then came back and went along with me. So, there's lots of ways to get that information before. If the judge wants to give effect, I think the judge can. And I certainly, probable FASD certainly shows a cognitive impairment. Like, what is the cognitive impairment? Do we have the evidence of what the cognitive impairment is? How do we present that to the judge? Okay.
Do you think there's a way that we could engage judges in learning more about FASD, like when they're hesitant or resistant to the information?
Absolutely. To me, I'll say very clearly, if a judge is not willing to be FASD informed, they are incompetent. They're not trained to do their job. And I think they need to be told that. And I've heard this, that occasionally judges will go, FASD is not talked about in my courtroom, or FASD is not relevant to what we do, or something. That's ridiculous. With the greatest respect, judge, get your head out of the sand. You have to learn about this. And one of the best conferences that occurred in Saskatchewan was a one-dayer with every judge and in Saskatchewan. And since that time, I think things have really changed. When we tried to change things here, and it's certainly not perfect here, don't get me wrong, we got a lot of issues, but we engaged the Court of Appeal Chief Justice, encouraged him to go to a sweat, to go to a powwow, which are very Cree things that happen in Treaty 6 territory. And those are things that judges should be doing. Judges should be getting out of their office and learning more about Indigenous culture, and certainly more about FASD as well.
Okay, thank you. Kate, can I let you go? Sorry, I cut you off before.
Oh, no, not at all. I was going to say, I agree with lots of the things that Glenn has shared, and also the importance of whomever has completed the assessment. And this is certainly not always feasible, nor always necessary, but sometimes it is really important to have the clinician forensically aware of the issues that the court's actually trying to wrestle with. Because if you present evidence in a case around cognitive impairment or mental health needs, and you don't help explain or translate, or as some of my forensic colleagues talk about, this forensic nexus between the kinds of difficulties that a person is experiencing and how those actually impact either the legal decision that needs to be made in terms of reduced culpability, or in terms of risk, or in terms of conditions that are needed, or in terms of answering questions around NCR or fitness. If you don't actually translate the strengths and difficulties that the person actually has into that framework, it can be ignored or missed or misconstrued or misunderstood. And I've certainly also read cases where descriptions of behavior that we might understand through an FASD or neuropsychological lens as being clear indication of impulsivity and poor planning have been understood without that translation as evidence of planning and of exactly the opposite. So I really think you need folks who are able to juggle both of those lenses to translate the information in a way so that it's actually going to be applied meaningfully in a case and not misunderstood.
Okay. That was very informative. So I think we have timed out today. So I'm just going to wrap things up. So on behalf of the Foster Family Coalition of the Northwest Territories and CanFASD, I would like to thank you for joining us over the past 5 weeks. We hope this webinar series has informed you about the complexities of FASD and its intersection with the justice system, and ways that these individuals, we can support them better. These webinars will be posted on the Foster Family Coalition's website by the end of October. For additional resources related to FASD and the justice system, CanFASD offers 2 online justice courses, one for Solicitor Generals and one for judges and lawyers. And information can be found at the website, and I think it's also linked into the chat. And I just wanted to thank our speakers for today and everyone who's attended.